while we wait for the court reporter, might it be possible for Mr. Spencer and I to get into a breakout room? I don't know what the term is on Zoom is, but a room with Mr. Neloms?
Sure. So, I saw Mr. Spencer. It's not actually a picture of Mr. Spencer, but his name and maybe Frederick Douglass on the screen there. Mr. Gary Spencer, Frederick Douglass, are you joining us also?
Yes, I'm riding Greg Richardson's coattails today.
There he is. How are you, sir?
Well, how are you?
I'm also well. Sure. What I'll do is move the three of you into a breakout room while we're getting set up, and then you all just rejoin us when you're done. If we get the court reporter before then, I'll send you a message to let you know. But there's no reason why the three of you shouldn't be conferring. So let me see if I can make that happen. All right, the three should get the invite. I don't know. Oh, wow, that was fast. Mr. Neloms is already in there. Great. I don't know who Ms. Corbett is. Is that someone, Mr. Plott, with you? Is that someone with Department of Corrections?
Department of Corrections, Judge McBurney. We've worked together in the past. I'm covering for Kimberly Beasley this morning.
Ah, okay, great. Thank you. We have indeed. I'm well. How are you?
I am great, sir. Great.
Thank you for getting us Mr. Neloms.
It's no problem, sir. Have a great day. I'm here if you need me.
I got it. You always are. Thank you. All right, our court reporter is working her way towards a connection to this. It slipped by her, but she'll be with us in just a minute. So I'm sorry to keep everyone waiting. Hopefully they're having a productive conversation in the breakout room. Hey, Ms. Rivers, you ready to go?
I'm ready, Judge. I do apologize.
No worries. I'm going to get the defendant and his lawyers out of their breakout rooms.
Okay,
It will
great.
Be
I'm ready.
rejoining us in 50 seconds.
Okay.
Mr. Richardson, you back?
We are, sir.
Fantastic. I just saw Mr. Neloms doing a little bit of calisthenics there. I think he's ready to go too. Well, let's get on the record. We've got our court reporter ready to go. This is case 17 SC 151116. It's State versus Andrew Neloms. Mr. Neloms was convicted of murder at trial in October of 2018. He is represented now by Mr. Richardson, primarily, Mr. Spencer as well. They are colleagues at Mr. Spencer's firm, but Mr. Richardson is his attorney of record for Mr. Neloms's appeal. We're at the motion for new trial phase of the appeal, and Mr. Plott is representing the state. Mr. Richardson, I've read your motion. It was very clear and well organized, and my read of it is that you set forth beyond the general ground that there insufficient evidence, which is actually something Ms. Bryant, the trial attorney, set forth in her placeholder motion for new trial, is that you have three substantive grounds. One, you argue that the trial judge, who was not myself, made an error when I think it was Judge Downs when she did not declare a mistrial after an FBI agent who was involved in taking Mr. Neloms into custody in South Georgia mentioned something about a gun. A second ground is a second purported error by the trial judge who did not conduct a Feretta hearing with Mr. Neloms when at one point in the trial, and I think it's important to the discussion we're going to have, or at least the analysis I have to make. This was in the middle of the trial. This was not before trial that Mr. Neloms raised his hand and said, I want to represent myself. In fact, the record sounds like he wasn't so sure he wanted to represent himself so much as get a different lawyer, but I'll let everyone make the record they want to make. And then finally, the third main ground is an ineffective assistance claim. And the allegation is that Mr. Neloms's trial attorney, he had three, but I think Ms. Bryant was the lead attorney, should have objected to what Mr. Richardson is saying is hearsay on the part of an investigator from the district attorney's office who was called to testify after a state's witness was stricken with amnesia and remembered nothing about anything. The DA investigator talked about a different version of events and an ability to recall that witness had when he was speaking with the district attorney's investigator. Mr. Richardson, are there any other grounds that you were planning on bringing up now, or are you confining yourself to what was set forth in your motion and Ms. Bryant's original motion?
Your Honor, upon conferring with our client, there was one additional ground that we would like to add and amend our motion at this time. The short of it is that we want to add to the ineffective assistance claim the grounds that there was a failure to challenge the arrest warrant for lack of probable cause.
To challenge the arrest warrant that would have been executed, I think it was in Savannah, wherever it was that Mr. Neloms was picked up.
Correct. We're suggesting that should have been challenged and for lack of probable cause, and it was not.
Okay. You will be free to ask Ms. Bryant about that. Mr. Plott, I'm not going to expect for you to have right on the spot case law in response. If it's something that the two sides need to brief, we can certainly allow that to happen. Okay. Mr. Richardson, anything else procedurally we need to? I guess I should get this on the record. It's clear to all of you, but it won't necessarily be clear on the dry paper later on. Mr. Neloms is appearing on this Zoom teleconference from Hays State Prison. His lawyer, Mr. Richardson, is appearing from a mood-lit room, not the courtroom. Mr. Plott is also not in the courtroom. I'm here just with Deputy Gordon. It's just the two of us in courtroom 8D, and everyone else is connecting via the Zoom technology. Mr. Richardson, anything else procedurally you want to cover? I'm going to ask Mr. Plott the same thing, and then I'll ask you to call your first witness.
No, not at this time, Your Honor.
Okay. Mr. Plott, anything you want to cover before Mr. Richardson makes his record?
Judge, unfortunately, because the claim that's now being raised for the first time at this hearing is an ineffective assistance of counsel claim, the state is unfortunately at a bit of disadvantage because we were not able to prepare questions for Ms. Bryant on this topic. We will proceed to the best of our abilities, but I would like to place on the record that this ineffective assistance of counsel claim is being raised for the first time at this hearing.
Okay, I think that's clear from the record. It is new, and Mr. Richardson has identified it as such. It flowed from an opportunity he and Mr. Spencer had to speak with Mr. Neloms while we were getting set up here to be able to go. So that's why I mentioned, Mr. Platt, that it may be that you asked for an opportunity post-hearing to brief it. I don't know what Ms. Bryant's going to be able to say about challenging an arrest warrant. By the time she got the case, I suspect it had been indicted. And I'm not making any legal conclusions at this point, but my understanding of the law is that once it's indicted, it doesn't matter if the arrest warrant was a bologna sandwich. The indictment would, in effect, supersede any defect in an arrest warrant. But again, I'm not making any findings right now. I want to put you a little bit at ease, Mr. Platt, that I don't know that had you known about this 3 months ago, you would have had any different questions for Ms. Bryant. But we'll see how it goes. Mr. Richardson, why don't you call your first witness, please?
We'd like to call Ms. Kenya Bryant.
Morning.
Good morning. And what I'm going to do, if it's all right with you, Mr. Richardson, is that I am going to do what we call the spotlight on Ms. Bryant, so that she's what everyone sees on the large part of the screen, even though part of the time you'll be talking and it may be part of the time Mr. Platt is talking. I think it's important for me, Mr. Neloms, and for the lawyers to be able to see the witness. We actually can see the witness much better than we could if we were all in court right now because of the way these cameras work. I'll note for the record. But thank you, Ms. Bryant, for taking time out of your day to join us. I'm going to have Deputy Gordon come on up here. And is she, I don't know if she can see, where can she see you? If you come up to the podium, she can see you. I'm going to have the deputy swear you in, sort of a funny process, but can you see, there's Deputy Gordon. All right, let's do this. All right.
Right here. Do you swear or affirm that the testimony will be given is the truth, the whole truth, and nothing but the truth?
I do.
Can you state and spell your name for the record?
My name is Kenya Bryant, and that's Kenya, last name Bryant.
All right, when you're ready, Mr. Richardson.
All right, thank you, Your Honor. Good morning, Ms. Bryant. Thank you for being here this morning. Really appreciate it.
Good morning. You're welcome.
So I guess we'll just begin. I just have a few questions. We've discussed a little bit about this beforehand, but can you just tell us generally what was your role in this case?
I was lead counsel in this case. I was the attorney assigned to Judge Downs from the conflict office, Metro Conflict Defender's Office, and I was lead counsel on this particular case.
All right. And do you remember generally like what the case was about, if that makes sense as a question?
Mr. Neloms was charged with murder. And so we were actually representing him on that murder case.
And do you recall the general theories of the case being presented both by the prosecution and by you? Meaning, what was the prosecution, what it was that the prosecution alleged happened in this case, as you recall it?
The allegation, as I recall, Mr. Neloms was accused of murdering a gentleman that was at the apartment complex where Mr. Neloms, or maybe him or his girlfriend, resided there. So there was some allegations that he was the suspect in this murder against the gentleman who was shot with, it appeared to be a shotgun injury to his chest as well as to his back.
And clearly there was like some differences between how the defense's theory of how these events unfolded and how the prosecution's idea of how it unfolded were, correct?
Yes, there was definitely some differences.
And what was the defense's notion of how these events unfolded?
The defense's position was that Mr. Neloms was defending himself. It was our understanding that the victim in this matter, the decedent, was the one who pulled out the rifle, and the rifle was obtained inside of the car, the vehicle that the victim was in, and that Mr. Neloms was struggling with the victim in this matter. And that is when the rifle discharged. And that was our take on it, that Mr. Neloms was defending himself. while, and this is how this incident took place, that he was actually defending himself against the victim in this case.
Thank you. And how did that contrast, as you recall, to how the prosecution described the events that what happened that evening?
The prosecution described it based on, it's been a while, but I believe that one of their key witnesses was a female who claimed that she actually heard the gunshots, and she saw Mr. Neloms running away from the scene. So I don't believe they had any eyewitnesses to the actual shooting. And I'm just going by my memory. But the person that provided the information that Mr. Neloms was seen running from the scene, we argued that it was very difficult for her to see the actual parking lot where everything took place. We went out to the scene, and where she said she was standing, you could not see the parking lot from that area.
Right. I want to ask specifically about where the gun came from, if that makes sense, right? And how, so the question is, how does where the gun came from differ in the defense's theory of this case versus in the prosecution's theory of this case?
The prosecution's theory was that Mr. Neloms was in possession of the firearm the whole time. The defense's theory was that the rifle was actually belonged to the decedent, and that it was in the car, the vehicle with him, and that our client obtained it in self-defense.
And if you recall, do you remember what the general state of, scratch that, that's a bad question. Was there much physical evidence in this case?
Physical evidence to support the state?
Prosecution's theory, yeah, the prosecution's theory. Or better question is, was there much physical evidence that connected Mr. Neloms to this particular crime on scene?
I think there was evidence to connect him to the scene, but I don't think there was enough evidence to connect him to the actual, well, there was evidence to connect him to the scene. There was evidence to connect him that he was involved in the shooting. I just don't think it was enough evidence to suggest that he had the gun initially. I don't think that I think that self-defense argument, I think there was enough to argue that there was self-defense, and he acted in self-defense.
Right. Now, we had a brief conversation about the general state of the scene, like whether there's forensics. And my question to you is, based on your recollection, what could have been determined based upon how, what was that? First aid is done. What things, as far as how things unfolded, in your estimation, could have been determined based upon observing any forensic evidence at the scene? Does that make sense as a question?
I believe so. For what I can recall, the markers that were left by the crime scene investigators, they seemed very, it was hard to really determine based on the markers what actually happened. The forensic or the blood evidence just didn't match up with the way that the state said that the incident took place.
Right. That's where we're getting at. And so as a result of that, what was the primary way that the state was able to introduce their theory of the case, or any evidence for the case at all?
I don't think I understand your question.
In short, since there wasn't a lot of physical evidence and forensic evidence that was able to outline the what happened that evening, according to the state's theory, how then did they present what happened?
They presented it as if Mr. Neloms just shot him from outside of the car. And they really didn't explain how the victim ended up inside the car.
Right. And I guess what I'm asking is more specifically is, what mechanism did they introduce the evidence through?
You mean by, was it witness testimony versus there was surveillance footage?
Right. I'm trying not to lead.
That's okay. You're doing a good job of not leading.
Yeah. But that's really what we're getting at. What we're getting at is how did they do it? Was it witness testimony? Was it through some other mechanism, or was it a combination of the both? How did they get there? How did they introduce what they wanted to have said?
Okay, and I'm trying to remember, but from based on what I remember, I know there was testimony, and one of the witnesses, like I said, gave that testimony that she observed Mr. Neloms running from the area, which we challenged because where she allegedly was standing, if you go out to the scene, it was just hard to see how she saw, what she claimed to have seen. Because of the way the stairwell is made. You can't see the parking lot. So that was one of the ways they presented it, through testimony from her. They also presented it through testimony through other people who allegedly had conversations about what took place. And I believe that some of those conversations, we are not sure if they took place or not, which there was some conversation that was had in front of an investigator. And then there were some conversations that were had in front of the lead counsel for the state that talked about what they believed they knew about the case. So it wasn't a whole lot of eyewitness testimony. It was more so conversations after the fact. And then, of course, the photos that were obtained from the crime scene tech after they assessed the area and took pictures. So that was how the evidence was presented from my recollection.
Thank you. All right. So, and that's kind of what I want to talk to you about. I want to talk to you about a couple of the witnesses that testified in particular. And you already described one of the circumstances, which is the conversations that happened for him. And so I want to talk to you about two witnesses in particular. One was Mr. Thompson, also known as Wu. Do you remember that witness being called?
Yes.
Okay, and then the second one that's going to be in relation to that is with Investigator Glenn, which you had referenced, not by name, but the investigator from the state's office, the prosecutor's office. So I guess what I want to ask you about as relates to Tabarius Thompson, also known as Wu, is do you remember how that testimony went?
I remember him not being willing to testify. I believe he took the fifth.
Yes. So Mr. Thompson had pled the fifth, but after he pled the fifth, was there further discussion about how to proceed with that testimony?
Yes, I believe that the state wanted to call the investigator that accompanied I can't remember if it was Mr. Abadi or if it was someone else from the district attorney's office that went to initially interview him. They wanted to call the investigator to have him come in and testify as to what the conversation was when they met with him initially.
Right. I want to go back a little bit to Mr. Thompson's testimony. We'll get to Mr. Glenn and the investigator and the calling of that. But I wanted to get back to Mr. Thompson's testimony in particular. Do you recall going back into chambers to discuss Mr. Thompson's testimony with the judge and Mr. Abadi?
I believe we did. I'm sorry, I can't. We went back to chambers so many times in this case.
Yeah,
but I believe we did.
Right. I guess the short of it is that, do you remember how do you remember Mr. Thompson invoking his Fifth Amendment right?
Yes.
Right. And do you remember that he was questioned? Was he questioned after invoking his Fifth Amendment rights?
Yeah, he was continued to be questioned. Yes.
Right. And did he consistently invoke his Fifth Amendment right?
Yes.
After a while, did he start to change the manner in which he answered his questions?
He was becoming agitated.
Right. At some point, did he start to generally reference just saying, I don't know, as opposed to still just invoking his Fifth Amendment right?
Right. He was starting to feel compelled to give an answer.
Right. And I guess the follow-up question to that is, were you guys able to cross-examine Mr. Thompson after he testified?
I believe so.
But at that time, was he still substantively giving I don't know answers and invoking his Fifth Amendment rights?
Yes.
All right. So now I would like to direct your attention to the testimony of Investigator Glenn. You had mentioned that the plan was like, I guess they were going to bring in information through Investigator Glenn. Do you recall how that testimony went?
He testified that they had a conversation, and that conversation entailed Mr. Wu, or that's how I remember him being referred to, giving them information that led them to believe that our client had committed this crime. I believe it was through some sort of conversation that he may have had with him.
I guess so. So we're describing what's going on. Investigator Glenn is saying in court, for the record, what Mr. Thompson had said outside of court. Is that correct?
That's correct.
Right. And would you agree that on the face of it, at least, is hearsay?
I would agree that on the face of it was hearsay, but I believe that was the whole point of him being there was to provide the information that they alleged that their witness was not willing to say on the stand.
Correct. And the final question as it relates to this particular line is, or two, did you object to the hearsay at that time?
No.
And do you recall why not at that time?
I believe our intention was because we had discussed that would be the reason why he was there. I believe that's why we did not object to what you would consider hearsay, because his whole point of being called was to talk about the testimony or the statements that were provided to the state outside of court.
Okay. And so that's it for the testimony related to Mr. Thompson and Investigator Glenn. The other question that we had is, did you at any time have a chance to review the original arrest warrant that was issued for Mr. Neloms?
Yes, I'm sure. Yes.
Did you at any point challenge the sufficiency of that warrant?
No.
When you reviewed the warrant, did you identify that potentially it lacked probable cause?
No.
All right. So then I guess the question that follows is why not challenge the warrant at that time?
We challenged quite a bit, but most of it were things that were already, the arrest warrant was not really an issue for us. At that point, Mr. Neloms had been in custody, I think almost a year and a half, almost 2 years. His case was indicted by the time I came into that courtroom. So I focused more on what actually took place in Savannah and was able to, in motions in limine, exclude almost everything that they recovered in Savannah. So we didn't really focus so much on the arrest warrant as much as we did suppressing what they actually were able to obtain out of the hotel room, text messages, guns, all of that. We were able to get all of that suppressed. And that's what we focused in on, the physical evidence that they obtained during the arrest.
All right. And I think that is it for our questions on that we have for you related to the motion. Again, thank you very much for being here, and we'll turn over what's witness to Mr. Plott.
All right, Mr. Plott, do you have questions for Ms. Bryant?
Yes, I do, Judge.
Thank you.
Ms. Bryant, I'd like to start by asking you several questions about your legal background before transitioning to your preparation for this trial, and finally conclude with some questions about your actions and decisions during trial. So first, at the time of trial, how long had you been practicing law?
This trial was 6
This
years.
trial was October 2018.
Oh, 18, 7 years.
And did your practice primarily center on criminal law?
Yes.
Specifically criminal defense?
Yes.
And at the time of trial, how many criminal cases had you tried that resulted in a verdict?
At that time, I think about 7 or 8.
And of those trials, how many of those were murder trials?
I believe 3.
Okay. And as it relates to your representation of Mr. Neloms, how did you come to represent Mr. Neloms?
I was assigned, I actually am a contract attorney with Metro Defender's Office, which is under the umbrella of Georgia Public Defense Standard Council. And I worked under Dennis Francis. He was my director. And so I was assigned to Judge Downs's courtroom. And so that Mr. Neloms' case was in front of Judge Downs. And so because I was the attorney assigned to that courtroom, Mr. Neloms became my client.
And did you meet with your client prior to trial?
Yes,
And did you discuss the evidence against him?
yes.
And did you and your client explore alternatives to going to trial, such as a guilty plea, or did Mr. Neloms insist on going to trial?
Mr. Neloms wanted a trial.
And turning to the trial itself, can you tell me what your theory of the case was?
Our theory of the case was self-defense.
And how did you attempt to advance that theory during trial?
We just punched holes in several of the forensic evidence, the way it laid out. We punched holes in the testimony that was provided by alleged eyewitnesses. And then Mr. Neloms himself even got on the stand to advance the theory of self-defense, and he testified.
And did any other defense attorneys assist you during this trial?
Yes, I had the assistance of Camille Reddick. She sat second chair, and trials are running together. I believe that we had Janie Hawkins that came in periodically to assist us with case law.
You also had someone named Gabrielle Bloodsaw.
Yep.
Would that have been an attorney, an intern, or who was that?
Gabrielle actually was an attorney in our office, and she sat in, she helped us review videos because this was one of those cases where we were receiving videos on a daily basis from the state. So she would be reviewing videos while we were actually in trial.
Okay.
And how did you divide up responsibilities amongst yourself for this trial?
Throughout the trial or during trial prep?
During trial prep and during the trial.
For trial prep, I did about, I would say about 65 to 70% of the prep, and then Ms. Reddick would assist with the remaining 30. So between the two of us, we did the trial prep exclusively. Ms. Bloodsaw and Ms. Hawkins just assisted during trial, and they were just dealing with fires that came up during trial. They would just come in and kind of deal with that so that we could stay focused on what was going on during trial.
And this may seem like a silly question, but were you paying attention during trial?
Oh yeah, we were paying attention.
And were you listening to the witness's testimony?
We were listening, but there, you know how trial is, it's a lot of moving parts. So it's possible that we could have missed something.
But did you object where you thought it was appropriate at the time?
We did. We did our best to.
And I believe that you went through this with opposing counsel, but you do recall a witness named Tabarius Thompson, aka Wu, testified?
Yes.
And do you recall that his testimony at trial was largely that he could not recall incidents associated with the murder of Mr. Brooks?
Yes, I recall him saying more so saying that he was pleading the fifth.
But at the conclusion or near the end of his testimony, do you recall the state confronting him with specific statements that he had made in front of investigator Glenn?
I do recall them challenging him on what he was saying that day as opposed to what he said before.
And that included the specific statements that he had made before.
Yes.
And do you recall that investigator Glenn was then called to testify about those statements?
Not that same day, but eventually he was called.
During the course of the trial?
Right.
And I believe that you said on its face it seemed like hearsay, but you didn't object on the basis of hearsay, correct?
Correct, because it's the discussion that we had with the judge that he would be called to testify specifically to what was said outside of court.
And are you familiar with the exception to hearsay for prior inconsistent statements?
Yes.
And did you
And
feel this? Go ahead.
I believe that's basically what caused us to not object, because we felt that that was the exception.
Okay. And I believe that you said that when you got this case, your client had already been in custody and indicted.
Yes, when I came into the courtroom, this case was already indicted. I believe it may have already been on the trial calendar. I can't remember.
And
But Judge Downs had what she called a rolling trial calendar. So once it's on the trial calendar, it stayed there until we were ready to try it. And I believe it was already placed on the trial calendar when I came into the courtroom.
And you did review the arrest warrant for Mr. Neloms, correct?
Yes,
But you decided to focus your attention elsewhere, including on the suppression of evidence that was obtained in the hotel room that he was staying in when he was arrested.
correct.
Thank you. That concludes my questions.
Mr. Richardson, do you have any follow-up based on the questions from Mr. Platt?
Sorry, I was having trouble unmuting myself. No follow-up questions this time.
All right, may Ms. Bryant be excused?
Yes, Your Honor.
Great, thank you so much, Ms. Bryant, appreciate it.
Thank you. You all have a good day.
Yep.
Mr. Richardson, do you have any other witnesses?
We do not, Your Honor.
Mr. Platt, any witnesses you want to call?
No witnesses from the state, Your Honor.
Okay, well, we'll close the evidence. We've heard from trial counsel. And I'm happy, Mr. Richardson, to hear any argument. You're also welcome to rely on the argument and case law set forth in your brief. That's up to you.
Yeah, I'd like to make a couple arguments if the court would indulge us.
I will.
All right. So I'll just go one by one. So our position on the first count is that a curative instruction does not go far enough. Substantively, what we have here is in this instance, what was going on is that before this witness was called to testify, right, the prosecution and everybody had a meeting saying, these are the things that we're not going to go into, right? We're not going to go into things related to the 9mm. We're not going to go into things related to the clip. In addition to that, it was determined that generally the statement was a custodial statement and was also not admissible. And all that was agreed to beforehand, okay? The issue here is that this case comes down to competing theories of how this thing unfolded, right? What you have on the one hand is the prosecution's theory that the defendant is walking around town with the gun and is and murdered the victim in this case just over a dispute, right? The defense's theory is very different than that, right? The defense's theory is that no, Mr. Neloms is not a guy walking around terrorizing the neighborhood with a shotgun. He was a guy who confronted a person who had potentially assaulted his girlfriend earlier. That person attacked him and tried to shoot him. A struggle ensued, and the gun goes off. The reason why this is significant, why this particular testimony is so significant, is that if the jury is allowed to hear that Mr. Neloms is walking around town with guns on his possessions, they'll be more inclined to believe or to lean towards the prosecution's theory of the case that Mr. Neloms was walking around Allison Court during that period of time with a gun on him, right? So that's why this testimony was not meant to be coming in. It was acknowledged by everybody that this is prejudicial. It's too prejudicial. And on top of that, it wasn't admissible anyway. However, prosecution elicits a testimony from the detective saying that, yeah, this guy tells me I'm walking around town, I got guns upstairs, substantively, right? I mean, I'm being a little bit, hyperbolic in the way I'm describing it, but that's basically what he's saying. It's like, if I have guns, if you find guns, they're mine, I got them, right? So the issue here is that the jury hearing that testimony is going to be predisposed to leaning towards the prosecution's theory of the case, and that prejudices our client in this regard. While under normal circumstances, a curative instruction will be sufficient, right? In this instance, we feel like it's not. The only proper way to protect Mr. Neloms' right to a fair trial in this regard is to have a mistrial at that time, because the jury can't unhear. You can't unring that bell. Mr. Neloms is walking around with guns, right? So we feel like on that ground that even though there was an objection made and the curative instruction was issued, that didn't go far enough, right? In this case, it needed to go further. Do you want to have Mr. Platt respond to that at that point or this point, or do you want to move on to my next point, Your Honor?
I'm going to let you cover your points and then I'll let Mr. Platt respond, but I do have a question for you.
Yes, sir.
As I understand the record, and it's only preliminary, I haven't dived into the transcript yet. Agent Dye, FBI, says what he says. I think in response to a pretty open-ended question, but regardless, he says something about not what they found, but what your client said, which involved, yeah, you may find a gun in the hotel room. Problematic, inconsistent with what the state said. So Ms. Bryant objects, and her request is curative instruction. And the judge agrees with that and does what the defense asked for. You're faulting the judge for not doing something that no one asked the judge to do. I just want to make sure that's your argument. And you may still be right. The judge has a certain obligation to do things sua sponte. Is that what you are contending, that even though the defense said this was wrong, please give a curative instruction, that Judge Downs's error was in not going further?
Correct.
Okay.
It's our position that it's not enough.
Mhm.
In that instance, given the way the case had progressed to that point, that we feel like there needed to be a mistrial at that point.
Okay, got it. Let's go on to the Ferretta issue.
Right. Our position here as Ferretta hearing is that Mr. Neloms unequivocally invoked his right to self-representation. Right. We understand that there is a different standard in changing attorneys, requesting a change of attorney pre-trial, right? And that once you're in the trial, Mr. Neloms does not necessarily have a right to change his attorney. But just because the trial has started doesn't mean that Mr. Neloms' Fifth Amendment and constitutional rights go completely out the window. In the same way that a defendant is entitled to representation, he's also entitled to not have representation forced upon him. In this instance, what we have is Miss Reddick's statements to the court weren't that my client is having concerns. It wasn't that my client is thinking about this. Her statement was, my client has requested to proceed pro se, and we feel like we should have a Ferretta hearing to inquire into that further. And our position is that that's what should have happened at that point. The manner in which the court had proceeded in this case was basically to dismiss Mr. Neloms' request, which was unequivocal at that time, in order to move the case along substantively. It was basically the inquiry went, do we have to do that now? But we're in the middle of the trial. Do I have to do anything at this point? And our answer to that is, well, if the defendant is saying, I want to move forward pro se, then yes. What's supposed to happen next is you conduct the Ferretta hearing. Just because the trial has started, it doesn't mean that he forfeits his right to self-representation. So we feel like in that instance, that again was reversible error. And what should have happened is that Mr. Neloms should have been afforded the right to represent himself. And we would also contend that even if what he's asking for is I want to represent myself, but leave these on, that is a remedy that is available to the court, to leave Ms. Bryant and Ms. Reddick on to counsel Mr. Neloms as to the points of law and just generally how it can go. But he should be entitled to represent himself. He shouldn't be forced to take on the attorneys against his will. That we should have had a Ferretta hearing at that time, and the inquiry should have been as to Mr. Neloms' mind state, not the expediency of the trial at that time.
Got it.
And moving on to the hearsay, I think that where we'll draw a distinction and a fine point of law here, in our opinion, is that one reason why I was asking this, if you go back and you look at the transcript, right, what you see from the testimony of Tiberius Thompson is not somebody who was testifying, I do not remember. What you saw was somebody testifying, I'm pleading the Fifth Amendment. And he was consistent about that for at least the first third of his testimony. He was saying, I'm pleading the Fifth Amendment. I don't want to be here. I don't want to testify. I don't want to incriminate myself. I'm pleading the Fifth Amendment. It wasn't until after they go back in the chambers and Mr. Abadi, if I'm saying that properly, is it Abadi or Abadi? Mr. Abadi comes back and begins testifying. It begins questioning him further, where he basically suggests you don't have the right to plead the Fifth Amendment in this case. That Mr. Thompson relents and begins to just say, well, I don't know. Our position is this, is that Mr. Thompson was asserting his Fifth Amendment right. And any statements made along the lines of, I don't know, or I'm not sure, or I don't remember, are substantively a continuance of him asserting his right to not testify in that regard, right? So how does that matter as it relates to the hearsay exemption? Is that, yes, the hearsay exemption says that, or the hearsay rule in Georgia says that if the person is available to testify and they testify and they're able to be cross-examined, then inconsistent statements can be brought in. Outside testimony or outside evidence can be brought in to impeach or to contradict. Even prior consistent statements as well as prior inconsistent statements. Our position here is that substantively, Mr. Thompson was not available to testify. Him asserting his Fifth Amendment right is substantively the same as him not being available to testify in this regard. So, and again, our position is that any sort of statements that amount to, I'm not sure, or I don't remember, are still a continuance of him asserting his right to not testify. I think that the context that I would put it in is that Mr. Thompson is, for lack of a better term, he's a street dude, right? Like, he is not an attorney. He's not an educated person. He doesn't know exactly how to elocute. This is how my rights are going forward. But what he made clear is that he wanted to assert his Fifth Amendment right. And it's not the place of the prosecution or the court or anybody else to try to dissuade him on the stand or try and find a way around him asserting his Fifth Amendment right. Our position, therefore, is that under these circumstances, Mr. Thompson was not available. He was not substantively available for cross-examination because cross-examination went the exact same way. I don't want to be here. I don't remember. I don't recall. Almost all of his testimony fell into that kind of category. So what we're saying is that the rule that exempts hearsay in the event that a witness is able to testify and be cross-examined is not applicable in this instance because substantively Mr. Thompson was not available. To draw a distinction, a contrast, Mr. Plott cites in his response brief, London v. State. In that case, what you had was a person initially saying, I do not remember, saying things like, my memory is bad, I don't remember. You can't trust what I'm saying because my memory is bad, right? And all the other cases that relate to this have similar outcomes where the person just, I don't remember. There's another case, I apologize for the citation, but there's an example where where there was a 911 call and the witness was called to testify. I was like, I don't remember what I said during the 911 call, right? But was able to testify about other things. In none of the other cases was it a person asserting, I am here asserting my Fifth Amendment right. And as a result of me being substantively cross-examined on my capacity to assert my Fifth Amendment right, I begin to say, I don't remember. As such, this is a case of actual hearsay. The entire testimony of investigator Glenn is hearsay as it relates to Mr. Thompson. Now, why is that significant? It's significant in this regard that, again, what we're talking about is competing theories of the case, right? It is the prosecution is saying, step back for a second. In this instance, there's no physical evidence. Most of the testimony that was presented against Mr. Neloms in this case was obscured views. It was dark. I heard something, but I didn't see what actually happened, right? That's the majority of the testimony. The part of the testimony on the record that gets in, this is how it happened, according to the state, is through Mr. Thompson. He was the one that was there near Mr. Neloms. And the state is saying that Mr. Thompson is telling them that, I saw him with the gun. I was there and he said that. And I stopped him after I said, you shot the man, you done killed that man, right? That is the state's case. And none of that is admissible because of hearsay, or it should not have been admissible. You remove that testimony, what you have is Mr. Neloms getting into a conflict. That testimony goes substantively unrefuted and then running because he panicked, right? And I say all that only to get to this idea, which is that this bit of hearsay is not insignificant, right? And as such, that it being hearsay and that the lawyers on the case all missed the objection to not allow it in this case is ineffective assistance of counsel. And but for that evidence being admitted, substantively the state has no real evidence putting has no substantive evidence refuting Mr. Neloms' claim of self-defense in this regard. And so again, but for this testimony coming in, we feel like Mr. Neloms would have had would have had a different outcome when this case goes to jury. So those are generally our arguments as it relates to the issues being raised today.
Anything you want to say about the arrest warrant?
Oh yeah, in addition to
Your new ground.
So in addition, the arrest warrant was we feel like the arrest warrant was insufficient. It didn't lay out sufficient probable cause. There wasn't enough specificity in the warrant to merit arresting Mr. Neloms, and that should have been challenged early on in the process, and it was not.
Okay, got it. Thank you, Mr. Richardson. And I'll give you a chance to have final word if Mr. Plott says something that brings to mind another argument you've got or any rebuttal you might have. Mr. Plott, your turn.
Good morning, Judge. So I'll address them in the order that they were raised by Mr. Richardson. First off was the allegation that the state committed prosecutorial misconduct and the trial court was required to sua sponte, declare a mistrial. First and foremost, the state did not commit prosecutorial misconduct. When the FBI agent who arrested the defendant was testifying, he testified that no weapon was found on the defendant. He further testified that as he was patting the defendant down, he asked if he had any weapons on him or anything that could hurt the agent. And the state's specific question was, and what happens after that? And at that time, that was when the agent volunteered. He, referring to the defendant, said he did not have any weapons on him, but he said if there was a gun, it's in the hotel room and it was his. At that time, defendant's counsel did object, and there was a discussion outside the presence of the jury. The defendant's counsel requested a curative instruction. There was no motion for mistrial made. And so the court gave the requested curative instruction in response to the request that was made by defendant's counsel. And so the state would argue that a party cannot complain of a judgment order or ruling that his own conduct procured or aided in causing. And here, whether there was a mistrial, whether they should have made a mistrial, whether defendant's counsel should have requested a mistrial, what they did was they asked for a curative instruction, which was perfectly reasonable to do under the circumstance. And so once the curative instruction was given, no further objection was made to the curative instruction and no motion for mistrial was made at that time. So the state's position is that this issue has been waived. While this court does need to evaluate whether a mistrial was essential to preserve the right to a fair trial, here it was not needed. A curative instruction was given, specifically the curative instruction that was requested by defendant's counsel, and the jury is presumed to have followed that curative instruction. So the state maintains that defendant's first enumeration of error is without merit. And then moving to the second issue of whether this court should have required the defendant to proceed pro se when he indicated that he wanted to go pro se mid-trial. Defendant's counsel brought to the court's attention that the defendant had expressed an interest in proceeding pro se. However, counsel was clear that it was more of just a dissatisfaction with his current counsel given the circumstances. And when this request was made, counsel put on the record that I don't think he quite understands how pro se works. When defendant was specifically examined about this, he asked for, quote, somebody who could help me, assist me, or be another representative. And he asked whether he could fire his lawyers and get another lawyer to represent him. That's not how proceeding pro se works. And the court did follow up later on with defendant. I would cite this court's attention to page 520 through 521, and that's in volume 3. And in that case, the court presented the defendant with the exclusive options of proceeding with his current counsel or representing himself. And when those two exclusive options were presented, the defendant represented that he wanted to proceed with his current counsel. And given all of that, it was perfectly reasonable for the court not to hold a Ferretta hearing and force the defendant to proceed pro se, given the representation that he'd made on the record.
You said 521 to 523?
No, 520 to 521, Your Honor.
Thank you.
Yes. And turning to the two IAC claims, the first one that was raised in the filed amended motion was the failure to object to investigator Glenn testifying to prior inconsistent statements of Thompson. As the state pointed out in its brief, when a defendant claims that he cannot recall, and he's confronted with the specific statements that he was made, that is a sufficient foundation for then those prior inconsistent statements to come in. And I'd like to point out this is being raised as an ineffective assistance of counsel claim because it was not objected to. And when we examined Kenya Bryant about this issue, she said that there had been a discussion with the court about this issue, and there was a determination made that this did fit the exception to prior inconsistent statements. And so it was perfectly reasonable for defendant's counsel not to raise an objection, and counsel was not deficient for not raising that objection. And Mr. Richardson made the representation that that was basically the only evidence that showed that this was a murder and conflicted with the defendant's account that this was self-defense. And Miss Cicely Ficklin's testimony was one of the key pieces of evidence here. She was the witness who observed the incident. And while she did not see the direct shot itself, she did see the defendant approaching the victim with the shotgun already in hand. And reasonably, she decided that she was going to try to hide in one of the apartments nearby, but she heard the shotgun blast, followed by Mr. Thompson saying that Black, you shot that guy, which was a nickname for the defendant. And so Miss Cicely Ficklin's testimony was also a key part, and that can't be underestimated when assessing the prejudice, even if we were to assume arguendo that trial counsel was deficient. I think there was other overwhelming evidence to rebut the presumption that he was prejudiced by this statement coming in. And finally, turning to the failure to challenge the arrest warrant, which
before you get there, what about Mr. Richardson's argument that really Mr. Thompson was trying to invoke the fifth, and whether it was the trial judge or it was the prosecutor, people kind of barreled past that and just kept asking enough questions and said, you can't say I take the fifth anymore. So he's like, I'll try saying something else. I don't remember. But that really what it was someone invoking the fifth. Are you familiar with case law that says, hey, if someone invokes the fifth, that is tantamount to, that's the wrong word, but it's analogous to a scenario where someone is saying, credibly or not, I don't remember. Because I didn't hear Mr. Richardson disagreeing that London stands for what London stands for. That's not a real controversial interpretation and application of the rules of evidence, that if a witness in the past was real clear, it's usually with law enforcement, here's how it went down, the witness takes the stand and suddenly gets the forgetsies, as long as that witness is confronted with his statement. Didn't you tell us before that Black, you tried to take the gun from Black in your apartment twice, and then he ran out there, and the person says, I don't remember saying that, then someone can come in to say, in fact, he said that, which is what happened in this case, except there's this overlay of, and I haven't looked at the transcript, I'm relying on Mr. Richardson, and I'm assuming he wouldn't say it if it wasn't in there, that when Mr. Thompson started out, he was saying, I'm not answering because I'm invoking the fifth, or words to that effect. Does that change the analysis?
Well, Your Honor, while the witness did try to claim the Fifth Amendment, the problem was there was no evidence that incriminated him that he had testified to. So he was not entitled to invoke the Fifth Amendment. And so when they come back before he starts saying, I don't recall, the court specifically asked, and this is on page 356, do you think your answer would incriminate you? And the witness says, no, it won't incriminate me because I have nothing to do with none of it. You know what I'm saying? And so then when the court represents, okay, well, we're going to proceed with this questioning then, that's when he said, I can't use my Fifth Amendment, and the court informs him, the Fifth Amendment is when you think you're going to incriminate yourself. And that's the first time that the witness says, oh, I think it will incriminate me then. But at that time, that's when we start asking the specific questions about the statements that he had made. And again, he starts to say, I can't remember, I can't recall, things like that. So that was when the state began to confront him. And as I said, this was an agreement that had been reached by the parties ahead of time, and this is being raised as an ineffective assistance of counsel. And I think the accommodation that was made, given the evidence in this case, as well as Mr. Thompson's involvement with it, it was perfectly reasonable for defendant's counsel to not object to subsequently investigator Glenn coming in. And I would point out that Kenya Bryant did cross-examine this witness. She testified today that she did cross-examine this witness. And so the cross-examination, I stand corrected. The cross-examination was actually done by Ms. Reddick in this case, but she did have the opportunity to cross-examine the witness. So I think that the argument that he was entitled to assert his Fifth Amendment and that the foundation was insufficiently laid is without merit in this case.
What volume is that? You said 356?
Yes, Your Honor. That's going to be in volume 2.
Thank you. All right.
And turning to the final ineffective assistance of counsel claim that was raised here today, that defendant's counsel was ineffective for not challenging the arrest warrant, I would direct this court's attention to Young versus State, 305 Georgia 92. That's a 2019 case. And it's quoting Goodman v. State, 251 Georgia Appeals 350 at page 351. And that's a 2001 case. And the quote is, where the defendant has been indicted and convicted, an illegal arrest based on a defective warrant is not alone grounds for reversal. And I believe also that we have a strategic reason here that counsel did not challenge the arrest warrant. She testified that the defendant was already in custody and that she strategically chose to focus her attention elsewhere. And that was on suppressing the evidence that was obtained in the hotel room. And this decision to focus her attention elsewhere was not deficient, and the defendant was not prejudiced by his counsel's failure to challenge the arrest warrant.
The cite to Young was 305 Georgia
92.
92. Thank you.
Yes. And the pin site for that's going to be page 99.
Thank you. All right, Mr. Richardson, anything you want to say in rebuttal to that, or you were expecting that and you've said what you need to say?
I'll just make two very brief points if it's okay.
Sure.
The first one, as it relates to the hearsay testimony in the Fifth Amendment, I would assert that our position is that the witnesses are lay people as well, and the structure of the Fifth Amendment is meant to protect people even in that position, right? Like if you were arrested, if you say I'm asserting my Fifth Amendment, questioning stops at that point until you have an attorney present and there's someone there to give you adequate counsel. I don't know that it's necessarily the witness's position to be able, or to be asked, or be put in a position to be able to understand what charges may or may not be brought against him, and have that be held against him in that regard, if that makes sense as a point. What I'm getting at is that once he says, I assert my Fifth Amendment, that should be somewhat the end of the inquiry under sort of or under different circumstances, but still applies here. I don't think that it's necessarily fair to say that, well, he couldn't articulate what charges he may have been facing, right? He knows that he's in the middle of a criminal trial and he was there when the guy got shot, right? And he's saying charges may be brought against me. I don't want to testify. Okay. So I think that we could push back on the notion of the Fifth Amendment, and as such, that makes him unavailable in our position. The second thing that I would respond to is the notion of all the other testimony that happened. If it wasn't clear before, there was other testimony, but the testimony was people not seeing what actually happened. It was people that were either due to impossibility of the angle from where they were to be able to see what happened, or openly testifying, I didn't see it, I turned away, all I did was hear it, right? So the only person, as I recall from the transcript, that really gave a description as to this is what happened, right? This is what I saw. I saw him come up with a gun and shoot him was Mr. Thompson. And so that's why that testimony is pretty significant, right? If you remove that testimony, what you have is chock full of reasonable doubt. It's people that didn't see what actually happened, that only heard it, that turned away, and that had impossible angles to view what actually happened. And so those are the only two pushbacks that I had at this time.
Got it. Okay. Thank you. Mr. Neloms, I had muted your connection because there was some background noise, but if someone could unmute it, I want to make sure if you have any questions of me about how this process works, you get to ask them. That's assuming someone is around who can come unmute it for you. So you're there. Do you have someone in the room? I can see you. Do you have someone in the room who can unmute for you? Doing the sign language. I can do ask to unmute.
Judge, I think he's asking if you can, or someone from your staff can do the unmuting.
Yeah, no, unfortunately, despite the, you're unmuted. Someone did it. All right. So, Mr. Neloms, we have heard the argument of the lawyers and some testimony from one of your trial attorneys. My question to you is not, hey, how did you think it went? Or do you have anything to add on that front? I just want to know if you have any questions about what's next. I need to enter an order based on the brief that your lawyers filed and the argument that I heard today. If that order grants you a new trial, it means what it says. You would then come back to Rice Street, and this case would be put back on a trial calendar. It might be that you guys work the case out, but it would be back in the posture of, hey, when can we be ready for a trial? If I deny the motion, you still have your direct appeal, meaning Mr. Richardson and Mr. Spencer will be filing an appeal on your behalf to the Supreme Court of Georgia, where they can make many of these same arguments. The main difference is that you won't be there for that. I won't be there for that. Argument with the Supreme Court is on paper, and then if there's oral argument, the lawyers are there, but you're not. Ms. Bryant wouldn't be there. There's no testimony. The lawyers get a few minutes to argue and answer tough questions from the judges. So that's what's next. Either we get you back here because I've granted the motion, although the state might appeal that, or if I deny it, then your lawyers appeal it to the Supreme Court. Do you have questions about that?
Kind of not really. Only thing I just want to do is add something and add a case law to something. One of
Hey, I'm going to interrupt you there. You have lawyers. You've got good lawyers. If there is case law that you want them to share with me, that needs to come through them. So that's the way the communications need to flow. If there's argument to be made or evidence to be introduced, it may start with you because you've got that good idea or you've done that research, but it flows through them. So either Mr. Richardson will file a supplemental pleading, or he can share it with me and Mr. Plott via an email before I enter an order. But you all can talk about that, but that needs to flow through your lawyers, okay?
Okay. And you're saying that that right now this was just the hearing, and that you haven't made your decision yet or whatnot about our hearing?
Exactly. Well, I've made the decision about a hearing. We had one, but now I need to make a decision basically about what you're asking for. You have, through your lawyers, said, Judge, mistakes were made and they were so significant that I need a new trial. The trial I got wasn't fair because, and you heard the reasons why, and I understand them. Judge should have declared a mistrial. Judge should have had a Feretta hearing with you. Your lawyer should have objected, all those kinds of things. If I end up agreeing with you, then you get a new trial. If I disagree with you, then you are not done. Then your lawyers will make these same arguments to the Supreme Court. When the Supreme Court rules, you're closer to being done. There are a few other avenues you have, but I don't get involved with that, and your lawyers can talk to you about that. Okay?
Okay.
So I'll enter an order. You'll get a copy of it. It won't just say yes or no. It'll have a lot of detail. I'll look at each of the grounds that Mr. Richardson has brought up and address them so that you'll know what my thinking is. And more importantly, if my decision gets appealed, the Supreme Court will know what my thinking is, and they'll be in a better position to say, McBurney, you got it all wrong. That wrong law, wrong facts, whatever it is they may decide.
All right.
All right, Mr. Richardson, anything else on behalf of Mr. Neloms?
Not at this time, Your Honor.
Okay, Mr. Plott, anything else?
No, Your Honor.
All right, well, thank you, everyone. Thank you, Department of Corrections, for getting Mr. Neloms online for us. It was a good connection, and we will wrap up for the day.
Thank you, sir.
All right.